So today we're talking about the one certainty in life, and that is death and how we can plan for it. So joining me today is the amazing Jane Cassell, who is based in the UK, as well as Rowan Stafford, who is based in South Africa. So these two wonderful people are very knowledgeable in this space, all things wills, probates, power of attorneys, and all the admin-y stuff that goes with it. So Jane, if you could just let us know, or just introduce yourself and let us know what drew you to this line of work and what's your why behind doing what you do.
Okay, so I do have a big purpose. Hello, everybody. So basically, I was the 9-year-old little girl who got nothing when her mum died. So one of the messages to come out is that in this jurisdiction, England and Wales, if somebody gets married, that does cancel their will completely. So when my parents divorced and they both remarried, and within a year of my mum remarrying, she died, which was not the plan at all. And that meant that her husband got all of her estate, which actually included my grandparents' estate because they had died 1 year prior to that. So I know that isn't what she would have intended for me and her other children. So yeah, so that's my purpose, which I only came to realize. It might seem so obvious describing that. Why do you do wills and probate? I only came to realize that when I came face to face with that man who took it all in 2017, and I was like, oh my goodness, that had a big impact. Some like 30 odd years later, and you realize, oh, actually, there's more going on, you know. So that's why I've always gone on and on and on about wills. It's because that purpose is there, like to encourage parents to take action, to raise awareness about marriage, cancelling wills here. I recall from a previous session with Rowan that it's not necessarily the case across the world, but certainly here completely cancels it, which can be bad news if you care for your children. So yeah, that's my why.
Thank you. Hi, Rowan. How are you doing?
Hi, Nikki. Yes, good. Thanks, Jane. Lovely to see you again.
Yeah, and you, and you.
Yeah,
So,
thanks.
Rowan, what is your why and what drew you to this line of work?
So I actually, when I studied, I specialized and did my master's in trust law. And particularly in South Africa, trusts and estates have always seemed to go hand in hand when it comes to law firms. And I did my articles at one of the big firms, and I was employed on one of the bases that are my knowledge of trust law. And with that came all the estates that flowed into that department too. We ended up doing one of the biggest estates the country's ever had, definitely probably one of the most complicated. So that was always a good one to cut my teeth on, as I'd say. And since then, I've been doing, estates, wills, and trusts ever since for about 15 years. Yeah, and just enjoying it, really.
Oh, great.
The wills, especially, you obviously meet a lot of different people from all walks of life, and that's also great. And every situation, everyone's needs are different, so it's not rinse repeat at all, which makes it quite interesting to do.
Yeah. Okay, so Jane and Ron, I do have some people that have emailed questions in, so I'll ask those as we go. But I have also a few questions to just start the conversation. So with Wills 101, if you can just like high level, just talk about what is a will and what is the worst thing that could happen if someone doesn't have one. I'm just also speaking from experience because my father passed away recently, and to our surprise, he does not have a will, so it's quite a good timing, I guess, for this session.
Sure. Yeah. Jane, I'll let you take it away if you want.
Okay, so I guess my example, me, that is an example of no will being a disaster. I feel absolutely sure that is not what she would have wanted, that a new husband got everything. That is a disaster. But in terms of the things that you have to think about in a will, I'd say there are three main areas. You need to think about executors, maybe guardians, and beneficiaries. So your executors are the people you're putting in charge. And I always think it's worth raising awareness that here, I always make the distinction in England and Wales, companies, banks, solicitors, lawyers will try to be your executors, or who would you like to act together with, JC, independent wills and probate, as though that's the most natural thing in the world. Then you're stuck with them because they're your executors, and surely you were paying attention. They get to charge for their probate services when you die. So executors, in my opinion, should be your family members if that's appropriate. So consciously think about it. Are they good with paperwork? Are they systematic? Are they honest people? Are they incentivized to get the job done because they're going to benefit? That is a good combination, you know. So executors in charge of the paperwork. And then maybe you have children under 18, and maybe you should be thinking about guardians. They can be the same people that you put in charge of the money to look after the children. Very different role, but you need to consciously think, who are your chosen people and who are your backups? That's the benefit of doing a will. And then thirdly, the beneficiaries, which might seem so perfectly obvious if you're a couple with kids, each other, and then the children, but think beyond that. So here, if you run out of people, and the law will say who it's going to be beyond what your will says if you haven't done a thorough will, but if you run out of people, it's King Charles. And I don't think any of us would write a will benefiting King Charles. So yeah. But Rowan always kind of brings out the differences in our different countries and the law that applies. So yeah, over to Rowan.
Yeah, thanks, Jay. So I think just high level in South Africa, for a will to be valid, it needs to comply with our Wills Act. Basically, what that means is, in essence, it must be in writing, signed by the testator at the end of the document, signed in the presence of two witnesses. Witnesses must be 14 years or older and competent, and they mustn't be beneficiaries, etc. Similar to what Jane said, I think in terms of the nitty-gritty, apart from the formalities, what's good to have in a will, obviously you need to appoint your executor, and an alternative is always important. Describe who your heirs are, what they are to receive, a residue clause for anything left over remaining. Obviously, if you have minor children, it's really important to appoint your guardians. And I'm sure what we'll discuss further down is also including a testamentary trust if any of your heirs are under the age of 18. To answer Natalie's question, if you die with a valid will, your estate will be distributed according to the Intestate Succession Act. What this means is, effectively, legislation will decide who inherits, and it works in quite a fair manner, but it's not perfect and it's not recommended at all. It's your closest family, spouse, children, or relatives inherit in fixed proportions, and it gets a little bit more complicated also when there's children involved. But yeah, that's basically in a nutshell the requirements of our will.
Great. I see that we have some questions on that. So Sandy has asked, does your will have to be held by a bank or financial institution, or could a friend be an executor?
My answer
In
to
South
that
Africa,
question,
certainly not. I don't know about Jane. I'm interested to know what
yeah,
Jane's response is actually.
So does your will have to be held? No, your will can be anywhere. I strongly urge my clients to keep their wills in professional storage. So we arrange that for our clients. There is now a meaningful will register that is not compulsory, but when you put it into professional storage, part of our process is to put the location onto Certainty, the National Will Register, which means it's going to be found. Some people think, oh, it's a great idea to keep it with the executor. Have they got a safe? Is the safe particularly safe? Is it fireproof, burglar proof, etc.? So professional storage generally is the best thing, in my opinion.
And can your executor be a friend? Or
Your
does it
executor
have to
can
be
be a friend. My conversation would then be, okay, if that friend isn't going to benefit and it's a big ask, it is a personal responsibility that is quite a serious one. Are you going to, I don't know, reward them with £10,000 or £2,000 or a sum of money conditional on them taking on that job? So again, that's about consciously thinking about your choices.
And the same in South Africa, Rowan?
Yes,
Same.
100% the same.
Yeah.
Yeah, but I wouldn't appoint an executor as a to do, and ask a favor. Like Jane's saying,
Mm.
it's quite a
True.
task and a responsibility, and they should be compensated for it.
Mm.
Yeah.
I mean, I'd say, a lot of people appoint the family as executor and they do not give them money, often because they are going to benefit in the will, so there's no need. But sometimes that person doesn't need the money. They do have the skills, and it would simply be an
Yes.
honor, and they have that conversation. This isn't a money thing. But yeah, but it's a case of exploring your situation and getting proper advice about that.
Mm.
Yeah.
We have another question on this. Does your will have to be signed by a commissioner of oaths in South Africa?
Just repeat that, sorry.
Does your will have to be signed by a commissioner of oaths in South Africa?
Mm. No, so as per those requirements I spoke about at the beginning, it just needs to be signed in the presence of two independent witnesses that are competent and over the age of 14. And on that note, what's really important is a certified copy or a copy of your will is not valid and not recognized in South Africa.
Okay, cool.
So you need the original.
Okay. And that's the same in the UK, hey Jane, you need the original.
You need the original, yeah. I mean, there are circumstances where, where you have to try and prove a will without the original, but that is not a good situation to be in. But yeah.
Let's move over to executors who you should choose and why. So, okay, so we could your executor of your estate say be a beneficiary as well, and should they be?
They absolutely can, and in my opinion, often should be. They're incentivized to get the work. I mean, if you appointed your neighbor, because if some people think, oh yeah, my neighbor, he was a bank manager, he's now retired, he's got the skills to do it. He's not interested. He's not interested. He's not getting a penny. He's really not interested. But your family who are going to receive it, they're interested in sorting things out. They are good people. But if they haven't got the skill set, or if they're a really dodgy family dynamics that means
Yeah.
it's very predictable that everyone's going to fall out straight away, then sometimes family dynamics are a good reason to appoint a professional. But thankfully, that's quite unusual in my opinion.
Yeah.
But yeah, absolutely.
Rowan, do you?
Good point. And obviously, same applies in South Africa. It's also obviously important that you would give, if you are choosing family or relatives, that you give them the power to appoint an agent, which may in that case be an attorney or other professional, just to do the legal work, because a lot of it is legal and very nuanced actually, and a bit of experience helps to go a long way in winding up an estate.
Yeah. Um, do you think that free will, what do you think about the free wills that appoint banks or lawyers as executors?
Well, everyone who's heard me speak before knows I am
I love
absolutely
it.
against it. They once they're in there as your executor, whether it's the kind of, oh, who would you like to act together with? My wonderful company. You are stuck with that wonderful company and whatever they're charging at that time. When actually, if you'd appointed your family, they might well have been able to sort things out for you. And if they didn't feel able, for whatever reason, which may have nothing to do with competency. They then have the freedom of choice to go to different lawyers, shop around. It's not the kind of thing you shop around for because of the energy and, grief. However, if a bank or a lawyer or an accountant are your executors, you are going to use them because they will say, oh, we're honoring that person's wishes. You have no choice. Whatever they're charging is what you'll pay.
Yeah. Awesome. Is there anything on executors you guys wanted to just touch on before I go on to guardians? I've got a
It's
long
just a
list
good thing
here.
to, yeah, it's a good thing to like review your will. So if you did do your will 20 years ago, 10 years ago, 5 years ago, if you remember that it was really cheap or free with your bank, then that is one aspect that is definitely, I mean, along with all the other aspects, but it really is worth checking your executors if you're
True.
looking back on an existing will.
Yeah, so review.
Yeah, and sort of to touch on two questions here, actually, what a lot of the banks, when you do your will with them, they will hold them. Um, and we don't have a nice national registry of our wills and whatnot, so inevitably they get lost or can't be located by the banks. But then you're left with an even bigger problem because by default you then die intestate again, which is another issue. But yeah, my default position is always to appoint your spouse if there's two spouses or oldest child or something like that, and give them the freedom to make that decision at the time.
Could you have more than one executor on a state? You could, hey, can.
Yeah, yeah. So
Yeah.
your starting point, as Rowan says, if you've got a traditional family, um, husband, wife, two kids, you might say in the first instance, on the first death, it's each other, and when you've both gone, it might be your two adult children. If people have got three children, then they're like, oh, should we appoint our eldest or should we appoint the three? Should we appoint two? But then one will be left out. Invariably, they'll appoint the three, unless one of them really doesn't have the skill sets or it'd be particularly stressful for them. Yeah.
Okay, so onto guardians, Jane. I remember in our last session that we had, you called them the cuddlies.
Yeah.
Um, so who should be thinking about guardianship in their will?
So anyone with children under 18, you need to be thinking, okay, if we both died, if both parents died and the child or children are under 18, someone's going to bring them up. In this country, we do have a care system, which is not one that people would want their children to go into. So you need to be thinking, often people are thinking their own brothers and sisters. Sometimes they're thinking up a generation to the parents, effectively the grandparents. That's not great long term because, if your kids are two, the next 16 years until the age of 18, things can happen. But sometimes people say, no, the grandparents are really competent and the right people right now. So we're going to do that and review it in 5 years. But you need to then actively review it at the right time.
Yeah.
But they are the cuddlies, you're right. Um, they cannot come to my office like they can with the executor role and say, can you help me with this, Jane? I definitely cannot help with that. It's a personal responsibility that they need to have agreed. Like you need to have a
Yes,
conversation. Would you actually bring up my kids if
yes.
we die? So yeah, that one, yeah. Executors, you can kind of spring it on them because they can shop around and get professional help, but guardians is really personal, so you want to have discussed it with them.
Yeah, I think the responsibility is a bit longer with
Yeah.
Yeah,
being
yeah,
a guardian.
yes, yeah, yeah, yeah.
Yeah.
And so, Ryan, I know in South Africa, like, what happens if you don't specify a guardian? I know that it's quite
Yeah.
a bit of a not nice process. So,
Yeah. So, I mean, by nominating a guardian in your will, you're expressing your legal preference for who should care for your children, if you're no longer around, while the final decision must still be confirmed by the High Court. Your wishes do carry significant weight and is usually followed unless there's a clear reason not to. So if you do not nominate a guardian, then the decision about who will care for your children falls to the courts, and this can lead obviously to uncertainty and delays, potential disputes with family members too. And obviously this is something you want to happen as quickly as possible if it ever occurs that your children need to be taken under guardianship.
there is just a question here on executorship that I just want to ask while we're on it, while we were on it. With more than one executor, does it not require all of them to be present and available to sign whatever they need to sign for after the event? This can be complicated if they live all over the world. How much paperwork is there after someone passes?
So my comment on that is that we're a lot more kind of online than we ever were, but there are things that need to be signed. That is a good question. Often, say if you've appointed three adult children, one of them now lives in a completely different country, the other two want to carry on and work together, then that third one might kind of step out. So in England, stepping out, never to come back in, is one process of renouncing power. But if you wanted to step out, but if you ever need to step back in, there's that flexibility, then that's called reserving power. So there is a process where people can step out if that becomes an issue.
There was just a question on a will, on an actual will. Does divorce cancel a will?
I saw that question. I was itching to go to it. So I believe in the UK, divorce also cancels a will. Is that correct? So in the UK, so England and Wales, the rule is that a finalised will, so a finalised divorce will remove that person as an executor and as a beneficiary. The danger period is the divorcing period where you still have a husband or a wife and the law expects you to provide for them. So if you are in the category of divorcing and it's not yet finalized, so that person isn't yet removed, then you need to do a will and an extra letter of wishes, a side letter saying, I didn't forget to provide for my husband or wife who I am divorcing from. My financial priority is now my children or some other beneficiary, because a judge is seriously asked by law to consider whether you forgot to include that spouse. Even if there is paperwork showing you're divorcing, the letter of wishes makes it really clear, no, 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 I didn't forget them. But once you're divorced, the will is still valid, but that person is removed from those two roles. But I mean, most people would, they just do a new will, get it done fresh. Yeah.
Rowan, somebody
Yeah,
also
I think
asked about South
the issue is
Africa.
when it happens when you die shortly after getting divorced, right? That would
Yeah.
be the big risk.
Rowan, somebody asked, is this the same case in South Africa?
So you get a grace period in South Africa. So if you get divorced and you pass away within 3 months of the divorce, your ex-spouse is treated as if they had died before you for the purposes of the will, but only if your will was made before the divorce, obviously.
And what point is it divorce? Is it a finalized divorce? Because we would
Yeah,
have
the
period
date
of
of the
divorce.
court order, yeah. You got
Right,
90 days, yeah.
right, okay.
It's not very, very long.
No.
Yolanda has asked, if I have shares in the USA and I live in South Africa, I believe I need a will in the USA. Where can I find this? What is required? Yolanda, I do have some information on this. I will send it through to you. But if your shares are physically not on your South African platform and they're in USA, then yes, you would need to have a separate will for that. But I have information on that. I will send it to you.
Yeah,
Um,
that is a good question. Wherever you have assets, you should consider having a will. So
yeah.
if you're in England and you've got assets here, have a will here. And I think we'll probably come to the kind of nuance of
Yes.
not revoking different wills later. But yeah, where you have assets, you should consider having a will.
Lisa has asked, is this info relevant for a US person, a US citizen? Yes, Lisa. So we are just talking about wills in general, but we have experts in both UK and South Africa just talking about that specifically. But the principles or foundations are pretty much similar. So if you have questions, please do ask them, and we will try and answer them to the best we can. We do have a contact in the US also. If we can't answer it now, then I can refer you to her after the session. Okay. So for beneficiaries, um, how do you help people think clearly about who should benefit from your estate? Because I mean, you have tricky family dynamics or estranged siblings, blended families. Um, yeah, or if you wanted to leave your assets to a charity, how does tax come into that? I know that's like a whole lot of questions in one, but I know that beneficiaries is quite, yeah, something that is, people just think, oh, it's just, let me just specify. Like there's a lot of things that people need to consider that they don't necessarily when they're trying to put their will into place.
Rowan, would you like to go first on that, or shall I just give you my
So,
spiel?
I would say that I'm always surprised how many people have asked me who their heirs should be, and it's obviously it's so specific to each person, and I try to remove myself from that decision, obviously.
Yes.
I can obviously give examples from past experiences of what's best, and obviously the needs of each person that you're considering. And obviously also where they are tax residents, if it's a South African estate, and you've got heirs all over the world these days, that's also a consideration. In which case, you could structure something like a trust that might be more tax efficient or something like that. But yeah, I'd say obviously it's up to everyone individually, but the best is just to get advice on how best to get the heirs to be paid once you've made that decision. That's where we come in.
Okay, I was slightly puzzled by that question in the sense that I feel like if my clients know exactly who I'm really sorry, I didn't turn that sound down. Let me do that now. Oh dear. I did the phone upstairs, but I didn't do the one downstairs. So my clients definitely know who they want to give to. Like if you're a couple, you want to give to each other and down to the kids, and they think that's the end of it. And I'm like, no, 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 you are going to go beyond that, because if you get on a plane for a big birthday bash, the plane comes down. Who would you want in the event of a common tragedy? So that's the bit they struggle with. What, you mean we both die and the children? Yes. You've got to come up with something, otherwise it's an inadequate will. So a professional will should be quite thorough, and anticipate stuff that you think really is the unthinkable, because you've got the ultimate beneficiary of King Charles. In terms of tax, which you said can be a consideration here, if you are taxable, the tax is 40%. But if you give more than 10% to charities, so registered charity with a registered charity number, an RCN, then the 40% tax is reduced to 36%. And the idea is it covers the 10% that, it's not exact maths, but it kind of covers it. But my experience is that people who want to give to charity will give to charity. They tend to be the daughters of vicars. That's a generalization. But most people do not want to give to charity, except in the ultimate wipeout event as an alternative to King Charles. They do not want to share it with their children, their brothers and sisters. They just don't want to do it. Sadly. So the big charities, we all know how much their finance directors are making, and people are turned off by that. So there's a lot less charitable giving than there might have been in the past through wills, in my experience. Yeah.
What is the role of your letters of wishes versus like the actual will in terms of beneficiaries, or because you don't necessarily want to specify. I don't know if everything's really relevant into a will versus putting something in your letter of wishes.
Okay, the big difference is that a will is legally binding. Like what's in it will go. The letters of wishes are not legally binding. They never will be, but they're really helpful guidance. So if you feel strongly about your jewelry passing to your daughter or your gents' watches passing to your sons, the letter of wishes is a great place to put it. If you put your Rolex in the will, the chances are that a formal valuation will be requested, and we have to disclose everything to the revenue. But sometimes, certainly in the case of my jewelry, it's really nice, but a formal valuation would cost more than the value of the jewelry. But if you feel strongly about your guitars, then you can put that in a letter of wishes. You can update it when you acquire a new guitar or when you give in your lifetime one of your guitars, and you can just update it as and when. But a letter of wishes is never going to be legally binding, but super helpful guidance. Yeah.
Rowan, somebody has asked, how does the tax benefit and charity donation work in South Africa? Is there a
Not as nice as the UK, apparently. So in South Africa, you get taxed at 20% on anything above 3.5 million of your assets, and it's 25% on anything above 30 million. Anything you give to a registered PBO, so qualifying charity, you would be fully exempt from tax. So you wouldn't, that portion of what would make up your taxable estate would be reduced, but you wouldn't get a nice tax break at all from it.
Oh, it's interesting.
But are the charities themselves exempt or not?
Yes, yeah.
Right, okay.
So, and that portion that you give to the charity is exempt, yeah.
Yeah.
Okay, okay. Makes
Yeah.
sense. All right. So cross-border considerations. Um, if you say had everything in one will, I mean, even though we say if you have stuff in one country, you'd have to have a will per that country. That's correct, right? And there's no way you can have a combined will to cover your assets all across the world.
So best advice, and Rowan can correct me if I'm wrong, but it is best advice here. Best advice here is that you should consider a will in every jurisdiction where you have assets. But
Mm,
remember that the beginning of a will is going to say, I'm revoking any wills that I made before, and this is my last will. So if you don't add some extra
Mm.
words along the lines of, but this is not legal advice, blah, blah, blah.
yeah.
Um, if you don't add words saying this will only relates to my assets in England, and for the avoidance of doubt, only relates to my English assets, and then if you've done other wills, and for the avoidance of doubt, does not revoke my Spanish will or my Brazilian will or my US will, then it's going to revoke all the other wills that you had. So you have to pay attention, get the
Absolutely.
advice in the different jurisdictions, and then coordinate so that you do not inadvertently revoke a will in a different jurisdiction. Having said that, so that's perfect advice. Go to each jurisdiction and take care not to revoke any of them by mistake. That's kind of perfect. Number two, we have a thing called the European elective, where you put special wording in referring to the European law that says that you can apply your English will to your European assets. So that's something to discuss with a specialist advisor. If you only have assets in England, Spain, and France, and you can group them together and do this EU elective or EU election, you can elect in your English will to apply that to European assets. And then your third option, I've certainly done a worldwide will, which is not recommended. It's not best practice, but sometimes circumstances mean you've got to is that in the real world, people say, "Oh, I've got this villa in Turkey, but I go on holiday there. I don't want to spend time in lawyers' offices, and I don't know who to trust." We would then do a will here saying, I'm purporting to apply this to my worldwide assets." Now, I can't advise what is the law in Turkey or China
No.
or wherever your assets are. What are their rules? Do they have forced
Yes.
heirship where you have to give to your father or whatever? But we can purport to do a worldwide will. Not
Mm.
recommended, but I've done them several times when people have
Possible.
said, look, in real life, I'm just not going to do it in that other country.
Mm.
Yeah.
Yeah. I think what's really important is obviously a lot of jurisdictions have different requirements, like Jane's saying, and we can't obviously speak to those
Yeah.
jurisdictions. So a lot of my clients think I'm just trying to sell them 10 wills instead of one. But yeah, I preferably just prefer to do one. Obviously, there's a few SADC countries we can do wills for, Mauritius, etc. But on the whole, we definitely say just this will only pertains to my assets in my estate in South Africa.
Yeah, and then come back to me when you go to that other country so I can check you didn't revoke this will. Because if you
Yes.
did,
Yes.
then we'll redo it
Yes.
quickly and then we'll sign a new one and we'll make sure that we don't revoke their one. So as
Mhm.
long as you keep in touch and discuss things, most things can be sorted whilst you're still alive, but you need
Yes.
to pay attention. Yeah.
So testamentary trusts. This one always also always like boggles my mind. Like, yeah, it confuses me sometimes. When would someone need to include a trust in their will? I mean, is it advisable that most people do that? Is there only certain instances where it would be advisable? Is it absolutely not necessary?
Mm.
Here, a classic thing would be if you've got disabled children. So if you have assets that if they had access to and they were what we call absolutely entitled to, they could just take it straight away. That can mess up support, benefits, and the whole way that they live their life. So you would have a disabled person trust.
Yeah.
Um, some people are really concerned that their children are already in a rocky marriage, and therefore they want to protect the assets that they leave
Mhm.
their their adult children. So that would necessitate a discretionary trust. Um, yeah, some people think, oh, shouldn't I put my assets into trust in my lifetime? And there are
Yes.
plenty of companies here that will relieve you of several £1,000s,
Yeah.
maybe even £10,000 in order
Yeah.
to relieve you of your assets. And
Yeah.
I'm not in favor of that. But it's for people to explore what's relevant for them and their circumstances. Often people think, oh, I need to put it in trust because of my tax bill. And actually, when
Yes.
you go through the allowances, they're nowhere near the tax thresholds.
Mhm.
You think, well, you're worrying unnecessarily. So again, it's worth having the conversation and understanding the numbers.
Hmm.
And Rowan, in South Africa, I know that they've kind of changed the laws quite recently, or changed the compliance around it.
Yes, for sure. Yeah, that was obviously due to our grey listing.
Yeah.
So yeah, I mean, just as a backdrop, obviously, for anyone who's unsure of the differences, a testamentary trust is triggered on your death, whereas obviously normal inter vivos trust, the discretionary trust we know is a living trust, as they call it in other jurisdictions, so that you can set up immediately. A testamentary trust is just triggered on death in your will. Those wills are typically much longer because the trust deed, as you would call it, normally is the terms that are set out in the will. So your will is now also a trust deed, so it's quite long. And there's many uses for a testamentary trust. It's highly useful. I mean, the most common, obviously, used purpose is for minors, anyone under the age of 18 that stands to inherit. If if you don't have a testamentary trust provision, allowing for this, their inheritance would go and be administered in the guardian's fund, as opposed to that heir until they reach 18. The guardian's fund is administered by the state, and it's definitely not ideal. There's also, if an heir is financially irresponsible and they want to delay the receipt of the inheritance, or just maybe stipend it or something like that. Also, special needs dependents also can be useful in that purpose.
I see Kerry has asked a question here. If we are in South Africa and we have assets in the UK, how do we physically do the will in the UK? Do you have to courier documents backwards and forwards?
It is a physical document. It is a physical document. So we would tend to bind the physical document and then post it out. And then it's got to be physically posted back for checking. Yeah.
We'll say courier in South Africa, Jane, because if you post it here, it'll never
Yeah,
reach its destination.
our
Yes,
postal service is not
I've
great.
heard that. Yeah.
Yeah, so we do the couriers. Um, I do have a question that was actually emailed in before we go to power of attorneys. This is from Eleanor. I found a service called Fair Wills in the UK that does fair priced wills. You can set them up for a fixed fee of £150 or £240 and change them if you need for just £10 a year. They also offer probate services at fixed prices. Have you heard of this company, and would you recommend or support it?
And that was called Fair Wills.
Fair Wills,
Yeah.
yes.
Yeah. I have heard of them. And that is certainly cheap. Um, it's for you to explore whether you're going to have a conversation. Some of these online services are online.
Yeah.
So, you've got to just consider how much advice would you get with that online service. But I mean, back in the day, I would do little experiments and pay the £100 and find out what sort of service,
Yes.
just to see what you're up against. And typically, they won't check that you've signed your will and got it back to them for checking. So that was my experience when I but obviously, I don't
Yes.
know their service, but just pay attention to the details, isn't it?
There was just an additional paragraph onto this that was more of a comment. So it's saying, I'm finding it difficult and frustrating to find legal services in the UK that are not willing to specify costs or even estimates other than as percentages of their estate value. If you have £100,000 or £200,000 in the same assets, it's not going to create an extra probate work to deal with it. What are your thoughts?
Okay, so we are going to come on to probate. My thoughts in a
Yes.
nutshell are that probate services definitely lend themselves to a fixed fee. But my experience of a fixed fee with my team is that it's based on the amount of work that needs to be done. So dealing with 15 institutions is very different from dealing with three. Dealing with a taxable estate, which necessitates the long forms rather than the short forms, is a different amount of work that will take a different number of hours. So yes, when that person referred to a percentage, the traditional way of charging for probate services is what we call a value element, which means a percentage. So you're giving them a legacy before they've done any work, plus an hourly charge. And when I was a trainee, that is absolutely what everybody did, and there was no other choice. But now there's more awareness about fixed fees and giving enough information so they understand, how
Yes.
many assets, is it taxable, what are the values, um, and then giving a fixed fee that the family can reflect on without any pressure and then
Yes.
decide whether they're moving forward. And also, I mean, I know we're coming on to that, but
Yep, we can
be
talk about
really
it
clear
now.
about what is included and what's not included. So if there's a house to sell, typically the conveyancing aspect of that is is a different charge from the probate service.
Yeah.
The probate services often get the grant only, but you've still got to go around and collect the assets in, or it's the full estate administration where they to redirect the post, sort out the gas bill, and it's everything. Insure the property. That's a completely different price from fill in the form and then send you on your way with that grant. So be really paying attention to the details of what's included and what's not. But yeah.
Rowan, do we refer to it? I say we because I'm in South Africa, probate here in South Africa, or do we use a different
Yeah,
sort?
so it is different. We don't have probate, but along the same lines of what Jane was discussing, in executors fees, that's we also have seen a trend to start fixing them. I always give the example that Jane's was very good. You know, if you have one house that costs 10 million rand in the estate versus 1 million rand investments with different institutions, there's a different amount of work involved. And every institution you add is an extra layer of pain and suffering for us because the institutions never comply. And obviously, another good point is obviously if the estate is taxable or not. And in South Africa, another question is the estate over 250,000 Rand or more? Because that there's a streamlined process in South Africa for states that are smaller states in that category. So yeah, but yeah, I prefer the you can sort of, I mean, look at a client's assets and gauge, if you were to die in the next 12 months at least, the percentage is fair. I've said in some cases, and in cases I said it's fair that we provide a fixed fee. And in any event, the heirs do have the authority to challenge that fee with the master's office if they believe it is unreasonable.
Yeah, I think my personal opinion about hourly charges changed when my painter lay back on my stairs and said, "Not being funny, Jane, but when I'm on a daily rate, I don't exactly rush." And 3 weeks later he was still painting, and you think, well, actually, I think fixed fee is just better. For me, I always go for fixed fee, and obviously I buy services. I have to instruct people, and fixed fee gives you certainty, doesn't it?
Yeah.
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 Hourly charges to me mean the more inefficient you are, the more money you get, and that doesn't make
Yeah.
sense. There is one
I mean,
question.
that's true. Sorry, Jane. I was just going to say, and like you say, what's important to know is that there's a lot that's excluded from that fee, like if there's any litigation or
Yeah.
tax disputes or accounting that needs to be caught up, and that would be separate anyway. So you
Mm.
know more or less what work is involved.
Yeah, yeah. There is a question that I think we must surely just cover before we
Yes.
move on to lasting powers of attorney, which is where someone said, I've heard people say that they have trusts to protect their children losing money in the case of an adult child's unsuccessful relationship. Um, So yeah, that's the whole kind of, oh, I'm worried about my children and their rocky marriage. That's in this country, that's a good
Mm.
reason to consider a discretionary trust. The other thing is the kind of blended family.
Mm.
So I mean, a very quick example, if there's say a second marriage, the husband arrives with his son, the wife arrives with her daughter and they marry. They are what we call a blended family rather than a traditional family. And he will surely be thinking about benefiting his son, but he's not really that interested in benefiting her daughter. So here, the solution for that is a life interest where you say, I'll give my spouse or my partner, you don't have to be married to do this, a life interest in the whole of my estate or um, the property, my share of the property, and it does have to be chopped and held as tenants in common for that to work. Um, but you can enjoy it for the rest of your life. But ultimately, when we're both gone, husband says, I'll give to my son, and she says, I give to my daughter. And that does cost more. There's a lot more advice involved. The property does need to be spot on for it to make any sense. Like it needs to be held the correct way. But that is a very, very good solution for blended families. So people who that's relevant for, make sure you have a chat and understand it. Yeah.
Just on that, Jane has further asked, can you give a life interest to an adult child?
You can give a life interest to anybody, but that question makes me wonder, um, why would you? In the sense, if you really, is it that you really want to give to your grandchildren, that you're thinking let the adult child enjoy it for their life? Yes, the answer to the
We have a
question, yes.
situation where we do something similar um, when we use an usufruct, which, for instance, I have a client who's on their second marriage. They're both on their second marriage. She owns the property, and she wants to leave that property to her children when she dies. But the male obviously lives on that property with her. They're married now. It wouldn't make sense for him to inherit it. He's well off in his own respect, but he wouldn't want to be kicked out if she died because the property's being inherited by the children. So that would be a situation potentially if that's the question they're asking. Yeah.
Does that answer your question, Jane?
You
Yeah.
mean Jane Bennett, don't you? Not me.
Yes.
Yeah.
Yeah.
Oh, Jane Bennett, sorry. Yes.
Uh,
Sorry.
if you're giving thumbs
Um,
up, I can't see people.
I
Ah, is
asked
that?
because the unsuccessful relationship situation.
Oh, okay. Okay. Well, then you've got to think, what are you really giving them? You know, are
Mm.
you giving them the ability to live in that property? You can do that. That would be an odd thing to give an adult child. Um,
Mm.
you would be more thinking in terms of a discretionary trust, wrap it up so it's protected, and then have it dripped out as and when it felt appropriate.
Mm.
Um,
Same, yeah, correct.
yeah. Oh, that was a question from Eleanor. Hello, Eleanor. I can't actually see all
Yes.
the screen, and yeah, there's
Oh, do you know Eleanor? Okay, cool. That's great. Yeah, Eleanor Barnes. She asked the
okay.
fair wills question. Yes. Okay, so on power of attorneys and living wills, um, what's a lasting power of attorney? Yeah, if you can just high level explain what it is and what's the one thing could often forget when setting these kind of things up.
So in the UK, we have two sets of documents. You've got the Property and Finances LPA, and you've got the Health and Welfare LPA. Whereas wills take effect only on death, the lasting powers of attorney are only relevant whilst you're alive. The big decision, the huge decision, is who your attorneys are going to be, like which people will you include. And it's often the same people as the executors in your will, but it need not be. And as a complete generalization and sexist comment, women, when they think about it, often want a woman in the health and welfare one. Not only a woman, but they
Mm.
would want to include one when they really think
Yeah.
about what the health and welfare really means. But yeah, Rowan, over to you.
Yeah, I mean, so in South Africa, it's a little bit more simplified. We make use of what's called a special power of attorney. There's no differentiation between property, etc. Basically allows you to give someone else the authority to act on your behalf in relation to a specific task, selling a property, access to a bank account, signing documents in your absence if you're temporarily incapacitated or abroad or something like that. Um, I think a big difference between us and the UK is we don't recognize durable power of attorneys, which means that when you later lose mental capacity, for example, due to dementia or a brain injury or something like that, the power of attorney automatically becomes invalid. So, and there's obviously solutions in South African law to deal with that. There's curatorship you need to apply for and so forth. But it's a lot more drawn out than signing a power of attorney, obviously.
Rowan, there was a question emailed in from Kerry. She said, I've heard a few stories where the master of the courts has refused to deal with an individual layperson as the executor of an estate if the value of the estate is over a certain amount. Please, can you explain the process or mechanic of things with how this would work if an individual has been appointed the executor in the will? Does the executor need to appoint lawyers such as yourselves first, effectively as the new executor, who then approach the master of the court on behalf of the original executor? I know we are advised not to appoint banks as executors, but I don't fully understand how it works if the master can turn around and refuse to deal with an individual that is appointed in the will.
Mm. Yeah, I mean, it would be concerning if you appoint someone in your will and then that isn't carried out because they're a layperson, for instance. I'm
Yeah.
not aware of that. I have many clients where I do the legal side of the administration of the estate, and they are, in all respects, in terms of administration of estates, lay people. I would definitely fight that if that is the case. I know this question is I've heard of, but the main requirement really for the master is that they must be residents. You can't have one executor that's non-resident. Although our law allows for it, the master seems to be using their discretion to not allow that anymore. But in terms of as long as you're a competent person, you be named in the will, I don't see why you cannot act as the executor. That being said, I would definitely, like I said at the beginning, rely on professionals where need be, because it will save you what you spend a bit of money will save you in time, no doubt.
Yes, definitely. Nola's also asked a question for you, Rowan. Can we apply to be a curator while the person is still mentally strong?
No, not in the sense of there's different curatorships, not in the sense that the person's incapacitated, that you have to actually wait for. I suppose they probably are preempting that. Um, there are other curatorships which aren't applicable here. So one to deal with a person's litigation, etc. But in that case, unfortunately, there's not that I'm aware of at least, or at least it hasn't changed since I last did one. That's not the case.
Okay.
In that sort of stage before they are incapacitated, that's when the special power of attorney would be useful. And that would also obviously be compelling when it comes to your application for curator.
Okay, there is a somebody else that has sent in a message. My dad wants me to inherit his house should he pass away. Currently, there is still a loan on the house, of which the insurance is cancelled on. I currently pay the house loan to him and live in the house. Should my dad pass away and there is still a balance on the loan, does this nullify the inheritance, or do you inherit the debt along with the house? I don't know what area this person is in. I don't know if it's different
Mm.
per region. I don't know, Jane and Rowan, maybe. I don't know if you'd have the same answer. Oh, it's in South Africa, based in South Africa.
Okay. I'd love Jane to answer anyway, just so I know the
Yes.
process, but I'm sure the legal principles are very similar in that you can't inherit debt. But obviously, as in an estate, you're looking at the
Okay.
net position, so you got assets less liabilities.
Okay.
In South Africa, what we would do is the bond would need to be settled. The debt is owed by the person who's now deceased, and you as the executor need to find a manner or means in which to settle that from the estate that you are administering. Ideally, if there's cash available, or there's a life insurance policy or something like that, or something you can liquidate in order to settle that bond or loan, and then you could give the property unencumbered to the heir, that would probably be obviously most ideal. I've had situations where that wasn't the case, so the bond was taken over by the heir. That's also possible, although not ideal. Yeah, so lots of solutions to that.
Yeah. So sometimes people ask me, oh, does a debt die with you? But sadly, no. The debt is still there and it has to be paid from the estate. So people need to think, if I give that property to that person, am I giving it with the debt? Or the benefit of a will is to consciously think, are you giving it without the debt? Are you giving it free of tax? So those are the little details that you would discuss with a professional. But as Rowan says, you've got options there, and
Yeah, it just reminded me, what everyone says, they want their last check to bounce, but that last check bouncing actually becomes your executor's problem.
Yeah,
Mm.
exactly.
yeah.
So I know we did touch on storage and safety, but digital copies are definitely not good enough, right?
They're not good enough unless something's gone horribly wrong, and you're trying to explain it. I mean, it's not the case of don't bother to keep copies. So I
Yes,
keep
yes,
copies, the
yes.
client keeps copies, and we put the original somewhere really safe. And if something happened, we would try to prove the copy, but we
Okay.
really don't want to be in that situation. That is not ideal. Um, Also, you don't want your lawyer and their firm and their office to have to be there forever. So I might not, retire. I might die.
Yeah.
Different things that might happen, and I don't want my clients to rely on my office still being in St Albans on London Road, for them to be able to access their documents. So I deliberately outsourced it so it's completely independent of me in a document storage facility designed to look after valuable documents. Um, but yeah, really valuable. We charge, it's a modest fee, it's £22 annually to give you a fee to compare with others.
Yeah.
But yeah, I think it's really important. And for us, having it noted on the National Will Register is valuable, because now if somebody dies and there's any question about, is this really the last will, it is professionally negligent to not search that register. It's that
Mm.
important now. 10 years ago it wasn't that big a deal, but now it's such a comprehensive, it's not compulsory, but it is a really good register that people do search the register after death.
Um,
Yeah.
Rowan, Yolanda has asked, do we have a storage facility like this in South Africa?
And we actually don't. And I think it just speaks to our demographic is probably very different. And a hard copy is way more uh, well, it's definitely more popular in South Africa. Um, we do a similar thing to Jane. Uh, Jane always, she's going to fall off her seat now when I say this, but we always advise to sign two copies of your will. We'll keep a copy, or you give it to executor and you keep one. It's very common advice in South Africa,
Yeah.
because we don't have that wills registry. We don't have a
Mm.
depot or a safe or anything like that nationally anyway that does that service. Also, if one gets lost or something like that.
Well, it would be just as devastating in this country, but we just don't do two. How can there be
Mm,
two? And how do you know
mm.
which one was the last one?
Yeah, it doesn't matter. Yeah,
Doesn't matter.
yeah, they're both exactly the same. So
Vanessa has asked, not a will question, but with regards to documents to have on hand in South Africa, should we be getting all our papers from Home Affairs as a digital copy, birth certificates, marriage certificates, etc.? I've heard not having this process can, or having this in place can really slow down the process.
yeah, so I mean, look, I mean, you need a couple of things to get the process moving quickly. Birth certificate's not one of them. But your marriage certificate, if you're still married when you die, is important that you've got a copy of that. And if you've divorced, that's been updated with Home Affairs. Because obviously, if you noted as being married with Home Affairs when you're actually divorced when you die, you which we're doing now, we're wasting 6 months on an estate just trying to fix that with Home Affairs first before we can actually even register the estate. So just the basic stuff, ID
Yeah.
copy, etc.
Okay.
If I can just very
Yeah.
quickly pick up on that, I don't know what this Home Affairs thing is that you've got going on over there. However, for the tax planning here, we have our own allowances, and then if the spouse died before, we can transfer their allowances as long as we can tick a few boxes, like they really did give everything to their spouse. If there's a property that it was your residence, and it's being given to direct descendants and blah 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 blah. But we have what I call a nil rate band pack, where you want to have access to the marriage certificate. And as Rowan said, this is for tax. If you're divorced and you really don't want them to have a claim, make sure you've got your divorce papers, your final consent order with your will. But for the tax side, and you know, you're happy family and whatnot, you want that marriage certificate, you want their will, you want their grant of probate, and all of those are public documents, but it makes life so much easier if you can just,
Yeah.
you know, line them up and put them in the envelope with the will. So they're all just there to help your executors ultimately.
Two people have asked this question, specifically for South Africa. How do you know if you're noted as divorced at Home Affairs? Is there a
Yeah,
website?
I did bring it up in case. So you just got to SMS the letter M with a space and then your ID number to 32551. That's 32551. So it's M and then your ID number, and you'll get a reply from Home Affairs, hopefully, with your marital status. So it would say single, married, divorced. If you don't get that SMS, which you often don't, reach out to me and we can do a quick search on the Home Affairs database to confirm it.
I will be sharing Jane and Rowan's details in the replay email for anyone that does want to connect with them. I cannot believe the time. I've got just one more question. Jane has asked, any advice on where to get estate planning advice for US expats living in the UK?
So did you say that you had a contact, or is that for US people living in US, or
But yeah, so that's just for
yeah,
the US specific.
yeah, I don't. It's the
Jane,
first
I'll
time.
also ask the US contact. They should have
Mm,
Mm.
that
yeah,
information.
yeah.
My understanding is it is also slightly different state for state, so it would also depend whereabouts the
Mm,
assets are located.
mm,
Okay. Yeah.
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 Never has to be easy. Never, yeah.
No,
Simple.
US very much complicates matters.
Yeah, 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 yeah. I mean, if people here have an estate and like suddenly you got, oh, Cadbury shares, which were always a
Yeah.
traditional English chocolate, but now it's US. So now, like the person's died, oh God, did you not shift those Cadbury shares before? Because you got to
Yes.
get medallions, and the US stuff is just a lot more complicated and
Yeah.
takes forever, and it just
Yes.
slows everything down. But sorry, US people, but it's true.
Are there any other questions? Can raise your hand quickly before we hop off. Jane, I will share those details for the US contact in the replay email. I just don't have it on me right now. Um, I don't share my Cadbury's with anyone. Yes, why should
Good.
you,
Well
Sandy?
done. Yeah. Good
Yeah, and they were
luck.
taken off the King's list last year, I think, hey Jane?
Oh, is that true? I didn't hear
Yeah,
about
Oh my
that. Oh,
goodness.
yeah,
yeah.
yeah.
Traitors.
Jane, Rowan, are there any final words before we hop off?
So I would just say, like, if you think you've got your documents from way back, check your documents. Are the executors a bank and you're shocked and horrified by that? Change that detail. Update guardians. If your kids are adult, maybe they should now be executors. And always just keep the beneficiaries under review. It might have seemed obvious before, but sometimes people do wills in challenging circumstances, having lost someone or whatever. So, you know, just kind of look back on the documents that you do have, um, and just check they're still what you want going forward. Yeah.
Rowan.
Yeah. Yeah, I think also I'll just copy what Jane said, but having a valid will is one of the most important acts of care and foresight you can give to your loved ones. And as we all know, it often goes overlooked. Don't delay. Review your will regularly, and there's lots of qualified professionals you can reach out to. But as we always say on this in this discussion, be wary of the cheap free wills because they normally come with a catch.
Yeah. Yeah.
And just very quickly, sorry, here, obviously the wills, you really do need professional help with a will, wherever you are. But lasting powers of attorney in England are supposed to be quite an accessible document to deal with yourself online with the Office of Public Guardian. So if you've got the inclination to read all the guidance notes, and really kind of, get yourself clued up on it, you should be able to approach that online with the Office of Public Guardian directly. If you want the support of a professional and all the advice that goes with that, then obviously reach out to somebody who specialises. But set yourself timescales. 2 weeks might feel too much pressure, but maybe 1 month to make some progress and decide what you're doing and how you're doing it. But yeah, set a timescale and get on with it.
And also getting the stuff sorted doesn't have to be heavy,
No.
Yeah. There is another question that has just come in. If you have put an emergency will in place, is it valid? So like if they write it by hand in the meantime until you can get a proper will set up in South Africa.
Yeah, it's not valid, like I said, unless it meets the requirements in the Wills Act. But you can do a handwritten will that's valid as long as you meet the other requirements. So obviously it's already in writing. It must be signed on the last page. It must be witnessed by 2 independent, competent witnesses over the age of 14 and so forth. If there are no witnesses and it falls short of the Wills Act, then your heirs would at some point prior to registration of your estate have to get that will validated by the High Court. So it is possible, but highly obviously not recommended. You can do a will very quickly anyway.
Yeah, I mean, I just to add to that, whether it's emergency or done in a managed way, a valid will is valid. And it's a little bit like pregnancy. It's either valid or it's really not. It's not sort of, it's not half, it's either valid or it's completely not valid. So, get that checked and send it to somebody to check for you. We can spot the obvious mistakes. One witness missing or whatever. People tend to be a bit friendly and check for you if you reach out and ask them to look at a copy for you. So, yeah.
Okay, thank you so much, Jane and Rowan. Always, I really do appreciate our tribe. Also, really appreciate you guys always willing to come on and share with us. So, thank you very much for your time. And I hope everybody has a great day further.
It's an honor.
Easter.
And great to chat with you, Jane.
Yeah,
Always good to learn from you.
Yeah, bouncing off ideas. All good.
Have a good day.
One day you're going to believe my double will, I promise you.
Yeah.
All right, take care. Thanks,
Cool.
everybody.
Take care, everyone.
Bye.
Bye.
Cheers. Bye.